Mediation Information and Assessment Meeting, MIAM. Court rules require that before making an application to issue certain kinds of family proceedings, the applicant must attend a Mediation Information and Assessment Meeting, known as a MIAM. Polite reminder. Please do note that this video blog article is not legal advice and should not be treated as legal advice. To consider with a mediator whether the dispute may be capable of being resolved by a method other than the court process. Mediation is a confidential process and none of the parties to mediation may provide information to the court as to the content of any discussions held in mediation and/or the reasons why an agreement was not reached. The court requires all applicants in the majority of family proceedings to have complied with this requirement before commencing proceedings, save in certain circumstances. The requirement to attend a MIAM does not apply to all family proceedings, but it does apply in relation to an application for child arrangements orders unless an exemption applies. If the exemption does not apply and consequently as the applicant, you must attend a MIAM. The rules state that the court will expect the respondent to attend the MIAM, but it is not compulsory for them to do so. If your husband, wife, partner or concerned person with parental responsibility declines to attend a MIAM, you will not be prevented from subsequently issuing proceedings. A MIAM may take place with either both you and your husband, wife, partner or person with parental responsibility attending at the same time or by separate meetings. Family court preference regarding child arrangements matters is consent not contest. The courts prefer for the parents to resolve matters through mutual consent, which at times can be reached through family mediation. The mediator is able to assess the facts and if found suitable for the mediation service, the mediator would contact the other parent or the concerned person to invite them for mediation. If the mediation is to progress, both parties can discuss and debate and try to reach an agreement regarding the living arrangements of the children. The parties can choose to reach an agreement in writing which can be presented to the court to consider and make it into an order. The court has full discretion to approve, update, change, call for a hearing, call for CAFCAS or social services as it may seem fit in the best interests of the children before the court approves the order. The purpose of a MIAM is to enable information to be provided about whether mediation may be a way in which your dispute may be resolved without going to court, the suitability of any other type of dispute resolution outside of the court process that may assist in resolving the dispute. If court proceedings are issued, the court will ask at the first hearing whether either or both of you have attended a MIAM. If an exemption applies, evidence of this will be required. The court will take into account any failure to comply with this requirement and may refer you to a meeting with a mediator before the proceedings can continue further. If you need support, you can contact us at help@incourt.co.uk or call us on 073 75 75 7510 or visit us at www.incourt.co.uk. We have supported many clients in making child arrangement order applications and can support you too if instructed. Please do note that this video blog article is not legal advice and should not be treated as legal advice.